May Lordship. Lordship, I beg to mention item number 14. Lordship, kindly this matter may be taken up after puja break.
Yes.
All right, Lordship.
After puja vacation.
My lord, I beg to mention one RFA. This matter may be released on 12th of this month.
12. One what?
RFA number 8/2023.
My lord, I mentioned item number 2 for the next date, and we already concerned the opposite party, and I'm on behalf of petitioner.
All right. When do you want it fixed?
After vacation,
Okay, after vacation.
Yes, I mean.
Mm.
Well, this is a joint application, my lord, by the application victim, my lord, for quashing of the FIR, my lord.
Joint application.
Joint application.
Husband, wife.
No, my lord, brother-in-law, my lord, accused, my lord, is sister-in-law, my lord,
Sister-in-law.
not the complainant. My lord. Here, my lord,
You want it disposed today or I will issue notice?
my humble submission, my lord, is this is at the investigation stage, my lord. This can be disposed today, my lord.
What is the section?
Section 454 or 454, my lord. The offense, my lord, punishment prescribed is 3 years, my lord.
Is the offense 454?
454. Four, 5 pound.
Trespass,
Housebreaking, my lord.
Huh?
Housebreaking, my lord.
house breaking.
My lord. On the record from the FIR, from the page of the FIR, my lord, we'll see, my lord, housebreaking would not be a thing, my lord, but then at this stage, my lord, I am not on the merit, my lord.
But what stage this case is pending?
Investigation, my lord.
Huh?
Investigation, my lord.
Investigation. FI should be quashed.
Of course, my lord. So I.
Fine. What do you have to say?
Your Lordship,
Joint
CD may be called for, Your Lordship. We
CD
have to,
has to
yes,
be
Your Lordship. Case diary may be called for. On
Let's
next
go
date,
to CD.
Your Lordship, this matter may be disposed, but let the CD may be called for. We have to look into the matter, what is exactly the material the investigation authority has collected.
I be my humble understanding, my
At
lord.
admission stage,
when
let
my-
us call for a CD.
My lord, suppose, my lord, I am not challenging. I have not invoked jurisdiction of this 482, my lord, and they are on merit, my lord. So we may CD insist on, my lord. CD, suppose I am challenging the merit, then only, my lord, CD will be required, my lord.
The informant you got.
I am not objecting the quashing of the matter on the basis of settlement. I am simply saying what material are collected.
Collecting for what, to understand the merit of the case, my lord.
Because, Your Lordship,
Oh.
yes, of course, Your Lordship, for 482, simply the parties have entered into the agreement, the court will not directly exercise the 482. The court has to see whether considering the material 482 is exercisable or not, Your Lordship. For that required, Your Lordship.
He is very correct. Let us call for a CD.
I was with a different opinion, my lord.
Now, no, issue notice also.
Well,
Yes.
And Mr.
Others-
Leonard counsel for the petitioner and Mr. T. Ade, Leonard Additional PP for respondent. The Leonard Additional PP has accepted notice on behalf of the respondent. So no formal notice is required to be issued. However, sufficient copies to be furnished during the course of the day. Call for the city, list the matter on
After vacation, my
After
lord.
vacation.
after vacation.
Obviously.
My lord. My lord, this is application order 482 for quashing of charge sheet. This is joint application.
Hmm?
Joint application, joint petition,
At the stage of?
evidence, my lord.
at the stage of evidence.
The consideration of charge will be conducted tomorrow, my.
So you have annexed
Yes, my lord.
state depositions.
My lord,
Have you annexed the depositions?
no, my lord. Consideration of charges will be framed
You want a matter to
tomorrow,
be
yes,
stayed?
yes,
We will stay and call for the city.
Yes, not CD or Lordship.
yes, LCR.
LCR, yeah.
We will stay and call for the LCR. I,
Oh.
Mr. Swain, so learned counsel for the petitioner and Mr. T. learned additional PP for respondent number one. The learned additional PP has accepted notice on behalf of the respondent number one. So no. Oh. Where is the state? Oh, okay. So no formal notice is required to be issued to respondent number one. However, sufficient copies will be furnished during the course of the day. Learned counsel for petitioners, huh? There are 6 petitioners. Petitioners have the petitioners who are both complainant and the accused
Yes.
have jointly filed this petition. As they do not want to proceed with the case, it is submitted that further proceeding will be an abuse of the process of the court. Considering the submissions at the bar, further proceedings of so and so case number pending in so and so court is stayed until returnable date. Meanwhile, call for the scan copies of the LCR, or we can call for the LCR.
Yes, your
Call
Lordship.
for the LCR. Scan copy is not required, you call for the LCR. This is the matter of
After vacation.
This is the matter after vacation.
Deeply obliged.
Oblige,
So no notice is required to be issued.
Yes.
oblige.
After some time. One. Motion matter, item number 1. Admission, oh yes.
It is my,
You're for the petitioner,
I am for the petition.
the other side, what about the other side?
Other side, my lord, there is a
Oh,
expert,
statutory appeal,
my lord,
statutory appeal.
statutory appeal. This is pending, my lord, since 2019.
So,
May I
sole respondent,
sole respect,
he's not appearing.
not appearing. Before the trial court also, we published in the newspaper, then only he came. In this case also, we have taken so.
He's
many-
the accused,
He's the accused.
so he
In
won't
check box?
appear. So he won't appear, check has bounced, so he is.
So kindly, since this matter is pending since 2019,
I will admit it,
can it be disposed of, my lord?
disposed of, no.
Otherwise, my lord,
Without hearing the accused, how can we dispose of? It will be against natural justice. He's accused.
he is accused, but then, my lord, since despite of,
We'll appoint an amicus curiae at least. Accused has to be heard.
this is NIA case.
I understand, but whatever it is, he has to be heard. If it goes against him, then he will be convicted. So he has to be heard. Conviction will sustain, if conviction will sustain, he has to be heard.
In that case, my lord, matter may be admitted. for hearing.
I'll admit it.
Otherwise also, my lord, what is happened in this case? Signature of check, learned trial court said it is proved that this is of accused person. But then what was? the
Then
question?
if it is proved, then the more it's important to hear the accused. If it has been proved against him, it is more important to hear the accused.
But then this-
Because he'll be incarcerated if it is proved against him. And in case he is incarcerated without hearing him, then it will be against natural justice. So we will, at least we'll appoint an amicus curiae. I'll just check the office note.
We have filed one criminal leave petition also.
Hmm?
We have filed one criminal leave petition
Hmm.
also. That is, criminal leave petition number 1 of 2019. That was allowed by this honorable court by order dated 13/9/2023.
Okay, I'll just check the order. Service of notices complete order dated 9/6/22.
My lord.
You have you have the list of legal aid counsel? Registry will appoint. Registry will appoint. And Mr. K. Kama,
My lord.
learned counsel for the appellant.
Appellant.
It is submitted that the respondent has been evading appearance. See the peruse the order of this court dated 9/6/2022 that service is complete. And peruse the order of this court dated 13/9/2023 in connection with criminal leave petition 1 AP of 2019. Appeal against acquittal was admitted after hearing the appellant, as the respondent was not represented. It is submitted by the learned counsel for the appellant that issue of check has been proved.
My lord.
The acquittal was, the order of acquittal was passed arbitrarily without considering the fact that the issue of the check was proved. The respondent was it strike this off, the respondent was full stop. It is submitted that the respondent was erroneously acquitted from the charges under section 138 NI. The respondent is not represented today. After considering the submission on behalf of the appellant, the appeal is admitted. The respondent is to be represented by a legal aid counsel. Registry to appoint a legal aid counsel to represent the respondent, who is not present today. Or represented today, not present as well as represented today.
After 3 weeks, ma'am. After puja vacation.
This will be for hearing, so whenever you want, the legal aid counsel has to be appointed.
Maybe listed after puja vacation.
This is the matter after puja. You want this back?
Highly always.
Yes.
Well, there is come up voting
admission hearing. So my lord, I'm waiting for the other party, my lord. President of the other party is my lord necessary. Because my lord, there will be the argument, my lord.
Only
Without
state is the other party, as
admission,
well as private respondent.
my lord, private respondent is there, but various step has already taken to the private respondent. And therefore, the order was passed on, my lord, 27/6 of 23, 27 June, that the step taken upon the private respondent has been completed. So it has been assumed that the step to private respondent is
When
completed.
is the order? 22nd?
My lord,
22nd June,
27 June, yes,
27 June, 22,
23.
22.
Service perhaps not completed, your lordship.
So we'll appoint a legal aid counsel.
Without completion of service, your lordship, how court can
Not
presume?
completed or not completed?
Not completed yet, your
Not
service.
completed. right?
If
Not
it is
completed.
complete, then your lordship can appoint, but if it is not complete, then presumption cannot be drawn, your lordship.
So my lord, what is required to check is, my lord, whether the AD card has returned or not. Various step has already taken.
They
to the
should have
private.
put in the orders column, I believe.
Yes, your lordship.
If service is not complete.
Yes, your lordship. It should be in the orders column.
You are for respond number one?
Yes, I am for the state, your lordship.
Seven ten, wakalat number not yet filed by any council on behalf of respondent number two. Service report in year 17/5/23. Service report in respect of respondent number two received from OC police station. And the same is kept with the records flagged.
That has to be seen, your lordship, whether it was completed or it has returned unserved, your lordship. What remark has been given by the concerned?
He said
Authority.
27 June. There's an order.
27 June. Well, 27 June, according to me.
Heard Mr. C. Modi. This matter is already ready as regards service and records.
Lordship, the plague mark is there, your lordship may go through it. The plague mark is there in the
After
record.
application. So service, I believe, is complete.
Plague mark is there, your lordship may kindly.
Then my lord, in such situation, let the matter be, my lord, taken about after vacation month.
Hmm?
If my lord, the service is not yet completed. Otherwise, what, my lord, my submission is that service. has already
Returning
been com-
this OC0, I'm returning the notice after causing service to the Samoni with respondent card number 2. Somebody has received also.
Okay, your lord, then service complete, your lordship.
Sri Nigar Rika. Nigi. Witness name Sri N. Tamang. Nigilian Rika.
my-
He's a respondent.
Yes, my lord.
Then your lordship may appoint a council
I'll
on
appoint a
legal aid
legal aid
service.
counsel.
Yes, your lordship.
C. Modi.
my lord.
Heard Mr. C. Modi, learned counsel for the petitioner, and Mr. T. Ete, learned relation PP, Arunachal Pradesh, for respondent number 1.
Yes, your lordship.
Service report on respondent number 2 has been returned, which shows that service is complete. See in the order of this court dated 27/6/23. The respondent number 3 is not, this is a petition. What? We may proceed also. Huh?
This is the petition for quashing of the order passed in 8/6/2021. 8/6/21. In GR case number 8 of 2016.
Let me see the order.
My lord,
Which page?
my lord will
Order.
find a page number, it is there from 47 to 40 to 70.
Hmm?
40 to 70, and particularly my lord, in page number 52. The main original copy was from.
This is executive magistrate's order.
My lord, this is order passed by the executive magistrate, wherein my lord, while proceeding under section 145, my lord, I have been evicted from the disputed area.
Oh, no. We will have to call the respondent. The rest is to appoint the respondent number 2 registry to appoint a legal aid counsel to represent the respondent number 2. List the matter on after punctuation.
Obliged.
May I proceed? Your Lordship, this is a joint application filed by the petitioner to quash the criminal proceeding pending before the CGM allow. GR.
Motorcycle accident,
Pardon?
accident case.
Yes, 279. It's a minor case where the parties have settled their dispute outside the court. So this may be quashed here.
Where is the FIR?
FIR is at page number 21. Twenty-one is handwritten and 22 is a type copy. May I read?
Yes.
I have the honor to inform you that today at around 8:30 PM, one Sri Minthoram and party who were flying on the Tata Sumo bearing number AR08A4438 hitting my motorcycle near my residence while I was coming back from the house of uncle. Then after they started to attack on me and beaten me and my wife. After they also taken away my motorcycle. Therefore, highly request your honor may kindly take necessary action
This
against
case is pending at which stage? Which stage?
prosecution witness.
Witnesses,
Yes, sir.
recorded or not recorded?
Recorded.
Recorded, how many witnesses were recorded?
Your Lordship. Last occasion, Your Lordship, if you see, Your Lordship, the complainant was appeared. Your Lordship will find the order passed by the CGM court, page number 77 and 78, Your Lordship. Page number 77. May I read? Case is fixed for PWS. Accused Mintoram, Aisha Ram and Bumri Basar are present and represented by Learned Counsel Mr. Idagwan. Learned PP.
Will dispose it? Joint petition.
Lordship, the file is not with me, Lordship, it is officer from other, this council was appeared last time, so I have to go to the file, Lordship, once.
Will let it give us some time to go to the
Lordship,
file.
for a timing, Lordship.
For the time being,
Okay. Your Lordship.
we'll dispose it.
Yes, Your Lordship.
Let us go to the file. After the file. Nobody is present.
May I please, madam? In fact, madam, here, madam, Mr. Ayapang, senior counsel. In fact, here, madam, in this matter, Mr. Ayapang, senior counsel is appearing, madam, because of his health issues, madam. I requested to appear for him on behalf of him, madam, and I have filed a wakalat nama also today, madam. Madam, this, madam, second appeal is being assailed against the judgment and order passed by the learned district judge, my lord, Pasigar, my lord. The judgment and order dated 31/7/2023 passed in appeal number 66 of 2022. My lord, the judgment will find at page 23, my lord. Is a second appeal, my lord. We have formulated some substantial questions of law, my lord. Here, my lord, by this judgment, my lord, the land has been, my lord, rights and title has been given in favor of the, my lord, respondent number 3, my lord. My lord, brief fact of the case is there, my lord. In
But
his,
what about the other party?
my lord, this is the first time, my lord.
Motion stage.
Admission, my lord. The second appeal used to come up in admission stage, my lord, even though it's a motion, my lord. First time, my lord.
Okay.
My lord, my lord, brief fact of the, my lord, case is, my lord, Initially, there was a Keva decision, my lord, against the land coal miner, Rasin Atik, my lord, which is situated near Pasika Township, my lord. There is a dispute, my lord, in regard by, my lord, in between, my lord, the present, my lord, appellant and the respondents, my lord. In that Kevang decision, my lord, it was held that, my lord, decision in favor of me, my lord. As land belongs to me, my lord. And thereafter, my lord, the two Kevas were held, my lord, without making me as a party, my lord, subsequent to the first Keva, my lord. In these two Kevas, my lord, subsequent two Kevas, my lord, the land has been declared in favor of the, my lord, respondent number 2 and the 3, my lord. So, my lord, I filed and, my lord, appeal before the deputy commissioner. When I came to know about these two subsequent Keva decisions, my lord, I filed a, my lord, appeal before the deputy commissioner. At that time, my lord, under 1945 regulation, saying that, my lord, this matter has already been settled by a Keva decision dated 7/5/2012, my lord. So it has to be upheld, my lord. But, my lord, what the learned deputy commissioner has done, my lord, he started to, my lord, try the case de novo, my lord. Without there being any challenge made to the, my lord, first Keva, my lord, by any agri party, my lord, and which has attained its finality, my lord. The deputy, ultimately, my lord, the matter was transferred to, my lord, the civil court, my lord, after, my lord, enactment of the, my lord, civil court act, my lord. Then, my lord, the district court has held in favor of the respondent number 3, my lord. My lord, for the issuance of the notice and for the stay of the, my lord, judgment and order, my lord, I will just bring one notice before your lordship, my lord. The sole, my lord, basis for, my lord, giving the land in favor of the respondent number 3 was a document dated, my lord, 5/8/19, 5/8/1975, my lord, which is lordship will find.
I will issue notice, no problem as such, but stay, I don't know.
No, my lord, only for the purpose of that stay, I will show one document, my lord, which
So
is.
if you issue notice, give 1 month time and then we will hear on the matter of stay as well as on the substantial question of law.
Well, or in the meantime, my lord, there may not be any execution of the judgment, my lord.
That will be stay. So we will decide both together, substantial question of law as well as stay.
Right.
That will be better.
Right.
We'll issue notice.
If my lord allows me to only show that aspect, my lord, the document which I want to
So
rely.
there will be 2 hearings. What is the point? On the substantial question of law also there will be hearing. Without hearing the other side also, we cannot frame the formulate.
Well,
the
only
question.
for a purpose of stay of execution, my lord. Well, a document has been relied on, my lord. The document which is relied by the learned court below is that it's a document of 1974, my lord, where it was, my lord, decided that, my lord, the land was, my lord, already settled between the parties, my lord. But the, my lord, the document whose the signature bears, my lord.
First of all, are you within the period of limitation?
Yes, madam. My lord, a
When
document
was the
has
last
been,
date?
my lord,
Last date?
does it okay.
Judgment?
A judgment was, my lord,
district
rendered on, my lord, 31/7/2023, my lord. The limitation period is 90 days, my lord.
90 days.
90 days, it's the second appeal, my lord. A document has been relied upon, my lord, of 1975, where signatures of the father of respondent number 3 was there, and but his father died in the year 1974, my lord.
Where is it?
My lord, that's what, my lord, lordship, the statement in the judgment, my lord, at page 61, my lord, deposition of the respondent number 3, page 61, my lord, kindly for a moment, my lord, recorded in the judgment, my lord. This is page 61 is the evidence of the respondent number 3 in whose favor land has been, the title has been given, my lord. Lordship will kindly come to page, my lord, 64, my lord. It is his, my lord, statement, my lord, recorded in the judgment, my lord. First line, my lord, he knows that there was a Keva in house of the Sri Madhagao withdrew
Page
his
64.
64, my lord. Continues his statement, my lord. From 61, my lord, his statement recorded has been reflected in the judgment, my lord. Page 64, my lord. Page 61 is to show that, my lord, is the evidence of the respondent number 3, my lord.
Okay.
My lord. And page 64, my lord. For a moment, my lord. First line onwards, my lord. He knows that there was a Keba in the house of Sri Madagao. Sri Madagao withdraws his signature from the decision of Keba held as his residence later on. His father died somewhere in 1974, my lord. It is the respondent number 3's statement, my lord. His father died in 1974, my lord, and the court relied the documents, my lord, of 1975. Lords will find that, my lord, document at page 340, my lord. I'm
This
sorry,
document, page 340.
340, my lord.
Yes.
My lord, this is the, my lord, one, my lord, Keba decision, my lord, in fact, a document. Lordship, second line C, my lord, it's in local language, my lord. Stilo dated 5/8/2019-75, my lord. Type copy is lordship will find at page 141, my lord. The signature at page 340, my lord. Father of respondent number,
That copy is at page 1,
page 1, my lord.
page 141.
341, my lord, 341,
341.
next page, my lord. Translated copy, my lord. Today on dated 5/8/1975, my lord. Whereas he himself said that, my lord, his father died in the year 1974, my lord.
What is the name of his father?
My lord, serial number 1, my lord. Makyom
Makion Gao.
Gao, my lord. Family meeting was held regarding Rosum land dispute between such and such, my lord. This has been relied in the judgment, my lord, itself, my lord.
Page 64.
Yes, my lord. This is exhibit, my lord, 6 of the respondent number 3, my lord. This has been relied in the judgment itself, my lord. Page, lordship will kindly see page, my lord, 157, my lord, of the judgment, my lord.
So Mada Gao's father is Makion Gao.
My lord. This document has been relied, my lord. And at page 157, my lord. After, my lord, 1, 2, 3, 4, 5 line, my lord, below, after 5 line from the top, my lord, page 157, my lord. Internal page will be 135 of the judgment, my lord.
Yes.
After 4th line, my lord, from the above, my lord. However, my lord, it is observed that the decision dated 5/8/1975 may not be existed, my lord. But the claim of respondent number 3 on the basis of distribution of the land during the lifetime of late Martingao and Maksongao cannot be denied. In the absence of any evidence refuted, the documentary evidence of respondent number 3, the documentary evidence of respondent number 3 exhibited as DP exhibit 6, my lord, whose my lord is just shown, throws light that suit land was decided land during the lifetime of late Relingao and Makyom Gao, my lord. Makyom Gao is the father, my lord. This has been extensively used by, relied upon by the judgment in the judgment, my lord. Thereby, my lord, the judgment has been given in favor of respondent number 3, my lord. Lordship will find the relevant paragraph at page 158, my lord. Paragraph 266, my lord. Page 158, my lord. The internal page will be 136, my lord. Paragraph 266, my lord. As a result, right, title, interest, ownership, and possession of the suit land measuring around 3 puras is declared in favor of the respondent number 3, my lord. This is one of my substantial question, my
So
lord.
what is the execution? Execution that he is already occupying the place.
My lord, yes, my lord.
How to stop the execution?
My lord, I am in the position, my lord.
You are in position.
Yes, my lord. That's why, my lord. Because of this judgment, my lord, they may execute in favor of him, my lord. So only for till the, my lord, after the vacation, my lord, till returnable date, my lord, execution may be stayed, my lord.
So
Till
then
return,
you will have to, I don't know.
we have filed one IA also, my lord, for staying of the execution.
Well, because there will be vacation, that's why we have some apprehension, my lord. So till returnable date, there may be stay of the execution, then they will come, my lord, for vacation of the execution also, my lord, order also, my lord. Because admittedly, on a, my lord, I will just say, it's a false document, my lord. Based on that document, it has been illegal and title has been given in favor of respondent. He himself said that his father died in the year 1974 and he is relying on a document.
No, that it cannot be said that it's a false document. You'll have to take the plea in the earlier case,
Yes, my lord, we have taken that, my lord.
earlier case.
Well, till, my lord, the returnable date, my lord, because now it will be vacation, my lord. So we have some apprehension, my lord. It may be executed, my lord. Till return, my lord may fix the date on, my lord, 8th of the November, my
There is
lord.
a process of execution. There is a time frame. Within the time frame only anything can be executed.
My lord, they may file execution petition before that, my lord, before in the vacation itself, my lord.
Execution petition is not required to be filed. You can,
No, there has to be, my lord, under the, my
but
lord,
there's a time frame. Then notices will be issued. You'll get to know about it.
my lord. Till, my lord, returnable date, my lord, only, my lord. Let the, my lord, matter be heard just after opening of the, my lord, court, my lord. Or my lord may say that, my lord, status quo of the land we maintain, my lord, till.
Not really willing to.
Yeah.
Not really willing to.
No, sir.
Will issue notice.
And then there may be an observation in my eye that, my lord, in the returnable date, my lord, there will be consideration for the interim stay of the execution.
What will take? One order will be sufficient
my lord.
for both the cases.
My lord.
Right.
Or, my lord, in the main case, my lord, notice may be issued. In the IA, my lord, that observation may be given. IA is for, my lord, stay of execution. my lord.
We can,
My
club both
lord.
the cases together.
Oh.
Heard Mr. R. Sukyal and counsel for the appellant. Both the cases together, I and B. Issue notice to the respondents to, how do you want to issue notice to the respondents?
Metro is registered
To
post, my lord.
suppose we return with AD, returnable with the after visa vacation.
My lord.
Do you want a date?
Yes, my lord, on 8th November, my lord.
Returnable on 8th November. I have considered the submissions at length regarding stay.
My lord, I am extremely sorry, my lord. In my lord, second appeal, my lord, what, my lord, under CPC it says, my lord, only after framing of the substantial question of law, notice is being issued, my lord.
But I have heard both parties in this court. And I have seen many cases where both the parties are heard and then substantial questions of law are framed.
No, no.
You can
It
submit
is-
your substantial question of law and the other party will submit
No.
their.
No, my lord, to my respectful submission, my lord, it is between the appellant and the court, my lord.
It is, sorry?
It is between the appellant and the court, my lord,
Uh-huh.
for framing of substantial issues.
It is true. Court will frame the substantial questions of law,
Only after, my lord,
but both
Issuance of-
parties are heard on the question of substantial.
and
questions.
in the final hearing, they will be heard, my lord, whether it's a substantial question of law or not, they will reply to that, man.
Yes, so then it will be framed after hearing.
No, my lord. Before that, my lord, substantial question is to be issued, my lord. My lord. My lord, order 42, my lord.
100 also? Section
100 also, my lord. My lord, 100, my
100.
lord, 100 subclause 3, my lord. In an appeal under this section, memorandum of appeal shall precisely state the substantial question of law involved in the appeal. 4, where the High Court is satisfied that substantial question of law is involved in any case, it shall formulate the same. The appeal shall be heard on question so formulated and respondent shall at the,
I will hear the appeal then only,
yes,
after formulating the substantial
yes,
question of
that's
law.
why, my lord, I'm sorry.
We will hear, certainly we will hear. the-
After framing of the substantial question,
Then
my lord,
after that we will hear. the-
then, my lord, respondents will be heard, my lord. Four is, my
Then it
lord,
shall be heard on questions of formulated
so formulated.
at the hearing of the. appeal.
And the respondent shall, at the hearing of appeal,
Yes,
be
that is
allowed,
what I intend to do.
be allowed to argue the case
That is what I.
does
intend
not
to do.
involve substantial question of law.
That is what I intend to do. So we'll issue notice to
My-
respondents. Issue notice to respondents, the question of stay. After issue notice to respondents, we won't hear them on this matter of stay.
Well,
After issue notice to respondents to so and so, so and so. Returnable on 8 November, did I say 8 November? 8 November. The question of the matter of stay of the execution of the impugned order will be taken up on the returnable date.
my- Bless.
Lordship, I'm praying for the passport matter. Because the leading
Passport?
counsel, yes, leading counsel is other court, engaged in other court. Senior
Another
counsel,
place,
no, senior counsel is engaged in other court.
time being,
No, matter may be fixed today, but I want to pass over the matter.
today your counsel will be submitting on the matter or some other day,
Today only,
okay,
Okay.
all right.
much.
This matter, I have received the copy paper book as matter may be fixed for hearing.
This one number 2 service is not complete.
Not completed.
AD card and response number 2 is not received till date. We'll await for service then.
Yes.
Service on the service report on response number 2 is awaited. This is the matter when you want.
After
After vacation.
after vacation.
आपका सुन रहे आगे कौन सा We'll check and see whatever is the order, then we will proceed for admission then. Original case record of POSCO case number received from the, then what about respondent number 2? POSCO case? No, nothing about respondent number 2. Acknowledgement card not yet received
Okay.
in case of R2.
So notice, served, lordship. Notice
Served.
has been issued or not, lordship, for respondent.
Acknowledgement card not received in respect of respondent number 2. That is on 21st August, then on 24th August, no, or nothing about respondent number 2.
Yes, sir, service not completed, your lordship. In the meantime, record has been received and paper book has been accordingly prepared. But there is no any nothing regarding the service of notice to the respondent number 2.
Hmm.
So service not completed, your lordship.
Not completed.
Yes.
We'll await then,
Yes, await and let the matter will be set after 4 weeks, your lordship.
or you can take a fresh step if required, because the
Appellant
notice
is not,
was issued before in the month of July.
appellant is not present, your lordship.
Oh, appellant is.
Yes, your lordship.
Service report on respondent number, I thought the person who just went, the previous.
Yes,
previous oral advocate. I thought he was the person representing.
Okay.
the appellant.
After 4 weeks.
Ah. Service report on respondent number 2 is awaited, leaves the matter after 2 weeks.
My lord, here also same thing, service upon respondent number 2 is awaited.
You want to issue fresh steps?
My lord, yes, I may be allowed
So
to take.
jurisdictional, yes.
My lord, otherwise my paperwork has already.
Same matter, your lordship,
Same.
this matter, same matter, your lordship.
Same matter.
Yeah, this one, to a criminal appeal 12 of 2023, wherein your lordship has passed the order just now.
Okay, okay, then, let me redo the order.
Because
You were
of,
not here, they were calling you, you were not here.
your lord, there is a difference in the cause list which prosecution side has received. There are many cases and numbering are totally different. And the cause list which has been printed out from the court, we have get from the court is totally different, your lordship, because of
And I
that
think
numbering.
same cause of action.
Yes, your lordship, the otherwise the same only, there's no service has been completed. Let them take fresh steps, your lordship.
My lord.
So, second one.
No, same, your lordship, because of the now listing, your lordship.
So for item number 7 is concerned, my lord, I have no idea about it. So I'm
Okay,
confined with the
item
item
number
number
8, service report on respondent number 2 is not complete.
My,
The appellant to issue fresh steps.
Fresh
Respondent number 2, no, there is one, 3, 4 and 5, I believe.
2 only,
2.
yes. There is his state and respondent number 2 is informant. So throw the policeman. Concerned
Service
police.
report in respect of respondent number 1, 2 and 3 are still awaited. 1, 2 and 3.
No 3 is there. Perhaps there is a,
Why?
It's
SC
item number.
is passing such order then? Respondent number 1, 2 and 3 in the matter of
so for my petition is concerned, I have only 2 respondents.
1, 2, 3. Item number 8.
8.
There are respondent number 1, 2 and 3 in item number 8.
My lord, as per all this, item number 8 is Charut Tamang and others.
Okay. So he is representing respondent number 7. The item number 7.
My lord, I am pointing out item number 8 of the. court
No,
case.
he is representing this item number 7.
Seven.
No.
Cause list सुद्धा बोलता है.
Item number 7.
My lord.
Item number
Correct, my lord, that's item number 7, my lord.
7, your lordship. 7 is the appeal.
So item number 7, just strike off the earlier order. Appellant, learned counsel for the appellant, Mrs. C. Modi is present. Learned counsel for the respondent, respondent number 1. Learned additional PP, Miss for respondent number 1, Mr. T. Ete is present. Appellant to issue fresh, appellant to take fresh steps to issue notice to respondent number 2 through the jurisdictional police station.
My lord.
List the matter on the same date.
Oh, my lord.
Oblige.
Mayor, lordship, today, I had to file the Vakalatama with the affidavit. But due to the road blockage, the respondents couldn't come for swearing. On the part of drafting, we have completed the draft portion.
This is the third time he is taking adjournment.
Yes, my lord.
So let
But
the
my lord, after vacation, meantime, we will file the affidavit with Vakalatama.
The learned counsel for the respondent, Mr. So and so has prayed for time to file Wakalatama along with the affidavit. The learned counsel for the appellant, Mr. S. Koyam,
yes, ma'am.
has raised objections stating that several adjournments have already been granted to the respondents to file their Wakalatama. The respondents are to submit their additional affidavit as well as the Wakalatama positively on the next date. This is the matter on when do you want
Just after vacation.
after vacation. So positively.
Oblige.
Oblige.
May I please, Your Honor? Hello, the service report with respect to respondent number 2 and 3 is still awaited.
All right.
We'll wait for the service report.
Service report on respondent number 2 and 3 is awaited. Please the matter after vacation.
Yes, Your Honor. Here also service is not completed on the respondent as yet.
Service report, when is for which respondent?
Your Lordship,
Respondent number 2, 3 and 4 still awaited.
I
Service
pray your
report.
Lordship, the respondent number 1, this is Deputy Commissioner, his name will be strike off from this.
Name to be struck off.
Yes, because we don't have any role to play in this matter. Your Lordship.
So you have no objection also,
No,
no objection. So you can struck off this.
Yes, Your Honor. But Your
If you
Honor,
feel like. If you feel like, but if you want him to be there, I don't.
even we have
It
been
may
having as a
be-
performer respondent. Your
consider on the
Lordship.
next step, Your Honor, after the appearance of the parties.
All right, maybe she has to take some instructions. Next day. Service report on respondent number 2, 3 and 4.
Yes.
Is awaited, list the matter after vacation. So you bring it up after the vacation.
Yes, Your
Advance.
Honor.
Affidavit filed by learned counsel for the original. For withdrawal of Wakalanama and the same is placed on record. This the petitioner, learned counsel for the petitioner has withdrawn the Wakalanama.
Oh,
So this item is without any advocate.
then it may be lost. Next step was after vacation. Then.
This is the matter,
Lost.
this is the matter after visa vacation. No
Right.
point, but I think it should go.
Lordship, may I? Lordship, this matter was listed yesterday. In our petition, the complainant name was not reflected, so we have implemented it.
Your complainants.
Yes,
Was not impleted. You have
it
impleted.
has been implemented today.
You have filed a amended cause list.
Yes, Your Honor.
Learned counsel for the petitioner has filed amended cause list to the cause title and as directed by the honorable court by order in it. So then everything is complete and we will release the matter for admissions. Or you will have to issue notice.
Yes, Your Honor.
Okay.
Notice me.
Oh, last time. I was with. Yesterday.
Yes, Your Honor.
So we'll issue notice there. The learned counsel for the petitioner has filed amended cause title. List the issue notice to respondent number 2.
Yes.
Issue notice to respondent number 2. How do you want to issue notice? The sooner the better. You are in a hurry, isn't it?
Yes. Yeah.
How?
Yes.
Also concern PS.
Through
Lordship.
the jurisdiction of PS. List the matter on the date
Lordship, after vacation. Lordship.
after vacation or you want a date?
Yes, sir. After vacation.
List the matter after
Yes.
vacation.
Like. It may be after vacation because other council is absent today.
Petitioner is not represented today. Learner additional PP, Mr. L. Hage is present. List the matter after vacation.
Like.
Appellant, huh? Not petitioner. This is pre-vacation feeling. Everybody is absent today. Pre-vacation, it's like the pre-vacation atmosphere. Everybody's in a vacation mode.
Exactly, no one is there.
Item number
19 is there also.
15.
My lord, my lord, as per code list, my lord, the respondent council, there is letter of absence is there, my lord.
As per causes,
Yes,
respondent council.
respondent council, my lord, Amber, my lord, letter of absence is there, my lord. So I'm for the petitioner, my lord.
Petitioner, yes, but he's not represented.
Yes, my lord, as per, my lord, code list, my lord, letter of absence is there.
Or letter of absence, I haven't seen. Circulated.
In cost is my lord. Name is,
Okay.
name is reflected, my lord. So, my lord, after project. Amber,
The
my lord.
learned counsel for the respondent has circulated. The learned counsel for the respondent is not present, has circulated leave, has circulated submission for leave. Learned counsel for the petitioner is present. This is the matter of transfer petition.
Yes, my lord.
This is the matter after puja vacation.
Yes, ma'am.
This is the matter after vacation.
My lord, interim order is there. Interim order is there.
Interim order shall remain in force till the next date. It was not continued last date. 28 is not continued. Not continued.
No, no, but I think,
Interim order not continued last date, 2/8 not continued, 28/6 not continued.
I think it is.
Okay, earlier it was continued. Interim order shall remain in force till the next date.
Much over.
Lordship, is the band application under section 439 of CRPC. So in connection to SAPA PS.
25.
Yes, it is there.
This is the agreement.
Yes.
Offenses also, I don't think. Thief, I believe.
Yes.
Housebreaking or no accident.
Excellent.
Accident.
They have 279 raised the again.
Yes.
Heard, Mr.
I bam.
I,
Bam. Idak bam units.
item number 5.
4 units.
Follows.
Oh, I heard, Mr. I bomb learned counsel for the petitioners. The so and so. Who is the informant here in this case?
Petitioner number 2 units. Petitioner number 2, Sri Iken Gade.
Where is the FIR?
Fire is at page number, you know, say 21 and 22. 22 is a type of yellow.
The petitioner number 2 is the informant and the petitioner number 1, 3 and 4 are the accused persons in connection with BSR PS case number. No, what is the PRC case number or GR case number?
GR number 308 of 2008
GR case number 308
of 2015.
2015. Arising out of BSR PS case number 6/15 registered under so and so sections. Heard Miss L. Hage, learned counsel for the respondent.
One.
Learned additional PP for the respondent state. The petitioners have amicably settled their dispute and they have buried their hatchet. The petitioners have jointly filed this application under section 482 CRPC with prayer.
Page number 2, for causing of trial proceeding.
to quash the criminal proceeding of GR case number 308 by 2015. This case is pending at the stage of evidence and at the stage of trial, the complainant approached the trial court with prayer to compound the offences, but the trial court by order dated which page?
Page number 77, Your Lordship, in excerpt 10, Your Lordship.
Twenty-two, 5/2023, in connection with GR case number 308 by 2015, rejected the prayer for compounding of the offence as offence under section 279 IPC is not non-compoundable. This impelled the petitioner to approach this court with the present application under section 482 CRPC.
This order, Lordship, dated 22/5/23, here the victim also present, Lordship, and upon the hearing, Lordship, he has also applied the court date, the case has been settled amicably, the page 78. Then it's a fit case for the settlement, Lordship.
The allegation against the petitioners against the other petitioners by the petitioner number 2 is that on 26/3/2015 at about 8:30 PM. The petitioners who were in the Tata, in the vehicle, bearing registration number AR 08A4438 of Tata Sumo make. Dashed against the informant and his wife, and they also assaulted them. Now, at present, both the victim and the informant are willing to settle the dispute amicably. Seen the page 75.
Lordship,
Yes,
page
Lordship.
78, Lordship.
75 is the agreement, Your Lordship.
Huh?
75.
Seen the deed of amicable settlement marked as annexure 9. Full stop. The victim has also agreed to
Settle the matter.
settle the dispute. Considering the submissions at the bar, I deem it a fit case to invoke the inherent jurisdiction under section 482 CRPC. To stop. The probability of conviction appears to be remote and bleak. Further proceeding will indeed be an abuse of the process of the court. In view of the foregoing discussions, petition is allowed and the proceeding against the other petitioners initiated by the petitioner number 2 is hereby registered as GR case number so and so is hereby quashed and set aside.
Highly ordered.
So these are the scan copies of the LCR, not the original LCR.
No, she can copy.
Huh?
She can copy.
May I please, Lordship? Lordship, FIR in page number 13. FIR is that, Lordship, Madam, it is to inform you that my sister, namely Miss Akap Chiri, age about 14 years, daughter of Sri Kapar Chiri, used to stay with a one named Bala Mukung, a town Baptist church, Colony Sapa, since class 7. And during her half-yearly exam in the year 2022, she was shifted to type 1 Colony Sapa and began staying with her sister-in-law, Srimati Rekha Sonam. Few days back, my sister complained that her menstrual had stopped since 2 months. As such, on dated 27/05/2013, my sister-in-law, Miss Rekha Sonam, took her to doctor at District Hospital Sapa for regular checkup, wherein she was prescribed to undergo some tests, which shall be done only on empty stomach. Thereafter, early in the morning of the next day, on dated 28/05/2013, She underwent ultrasound test, and as per laboratory test, it is revealed that she is 19 weeks and 3 days pregnant. Enclosed here in original medical prescription and laboratory test report for your kind perusal and reference. Upon seeing this result, all the family members were utterly shocked. Thus, we began inquiring about this, and on being asked, she disclosed that above named Sri Bola Mukong has impregnated her as he had sexually inter.
Item number 13.
Yes, madam.
This is item number 13 is application under 227-115 CPC for setting aside and quashing the civil proceeding of title suit 6/18.
Yeah.
Huh?
Yes, madam.
So item number page 13 is the FIR.
Page number 14 is the FIR. Against this FIR, title suit is filed before the learned court below.
Okay, yes.
Page number
I
14
got it,
election.
yes.
Yes. And now, my lord, this FIR has already registered as an open PS. Yes, my lord, after, during pendency and after registration, no title suit against allegation level in the FIR cannot be, title suit cannot be live. So Lamet Court below has no jurisdiction to pursue any defamation case against the FIR which is registered. So my lord, preliminary objection come reply was filed before the learned court below for maintainability of this title suit. But learned court below has not dismissed my objection for maintainability of the title suit. So order is, my lord, page number 19 and 20 is order passed by the learned court below, dismissing my written statement come preliminary objection.
Page number 19 and 20.
20, yes, my lord.
Please read the order.
My lord, the plaintiff is represented by learned counsel Sri K. Tama. The defendant is represented by learned counsel T. Shiva. The defendant was directed to file WS within 2 weeks from 14/6/19 as last opportunity, but the defendant has not filed WS even after lapse of 90 days. Instead, a preliminary objection was filed by Miss case number 27/19, which has been heard and dismissed today.
Yes, yes, I have read it. And page number 20.
Page number 20. May I read my lord? The miscellaneous case number 27 is filed by the learned counsel T. Shiva on behalf of the respondent number 1 and 2, raising a preliminary objection regarding maintainability of title suit number 0618. Copies are to the learned counsel Sri K. Tama, learned counsel for the plaintiff. Heard both the learned.
I have read it, yes.
Yeah.
So I guess,
So, my lord, when FIR allegation level in the FIR is registered, is under investigation, no defamation suit cannot lie. So I prayed my lord.
please read the FIR.
My lord, may I read? To the officer in charge, police station Nyopin, district Kurongkume, Arunachal Pradesh, subject first information report. With utmost regard, we have to inform you for your kind notice and immediate apprehension of the culprit involved in the instance case that
On 24/1/2017, we on behalf of Leong Village file a complaint before the ADC Nyopin against Sri Tadargari Tadar Tanya Panong Village for settlement of the land dispute of Darch Hagam Rayar Langdo land. On the basis of complaint, the ADC Nyopin in accordance with the provision of Assam Frontier Regulation 1945 passed an order by appointing different PIs, HGBs, GBs as supervisors and judges respectively. Accordingly, the mail proceeding local case was held on 30/1/2017 and 15/3/2017 at ADC's office Mail Hall, Nyopin. But the appointed supervisors and judges could not able to settle the said land dispute between the parties in the mail proceeding. Therefore, another mail proceeding was fixed on 10/10/2017.
All right, then, David, yes.
So,
So according to you, this civil proceeding will not lie.
yes,
Why will it not lie?
Your Honor, my allegation level in the FIR is registered. It is under investigation.
And then
What-
finally, registered.
Yes, whether my allegation is false or correct, it will reveal after investigation.
So you want the proceeding to be quashed?
Yes, my lord.
All right, this is your prayer?
Yes, my lord.
Yes. And 14, what about 14? Item number 13 and 14.
Both are take together because that FIR, which my learned brother is saying, that FIR, in fact, that was registered on the director of learned CGM, 0. The same CGM. He is a civil judge senior division also, and he is chief judicial magistrate, 0. Now, interestingly, what happened, my lord, in this case, that FIR, despite of its submission before the officer in charge Nyapin, officer in charge Nyapin did not found any prima facie case in that FIR. So
But
therefore,
he is saying that the case has been registered.
I am coming on that. Thereafter, what they have done, they have filed a complaint case, CR case, before the same court, Chief Judicial Magistrate, UPR, 0. Thereafter, learned Chief Judicial Magistrate, partially what erroneously jurisdiction that was exercised, he took cognizance of the offense, recorded the statement under section 200 CRPC of the complainant and witness. And thereafter, as per Honorable Apex Court, when you take the cognizance, you cannot direct for a registration of FIR. That is a settled proposition of law. And furthermore, while taking the cognizance, there are some sections of IPC that is absolutely barred under section 195 of CRPC. The offenses that falls under the categories that is barred by section 195 of CRPC that cannot be taken cognizance of. And thereafter that learned magistrate, Chief Judicial Magistrate directed the SP Nyapin to register the case. Accordingly, the case was registered, but that was not based on that FIR my lord. So therefore, both the matters it take together to adjudicate properly and to decide the issue. Now, what my learned brother is saying that since the FIR is registered, therefore this title suit is not maintainable. They should have raised those issues before the learned trial court, that is the civil judge senior division. And very interestingly, instead of filing written statement, they have simply filed one IA in this case. Therefore, learned civil judge senior division rightly has of the opinion, you first come up with the written statement, as because 90 days mandatory period is already lapsed. Still, I am giving you a chance so that you can file your written statement. Thereafter, under the provision of Order 14, preliminary issues, if suppose it has to be framed, this court will decide. Then, without filing the written statement, out of ego, they approach before this honorable court by filing this revision petition. Therefore, in my reply affidavit in opposition, I have clearly narrated. Kindly those may be taken into consideration while disposing of the matter.
Affidavit in opposition in this
In
item
this
number 13.
item number 13, my lord.
14 item.
I'm the opposite party. So I've succinctly brought entire thing in paragraph 2, my lord. So therefore, my lord, thereafter, my lord, what happened? They have even filed a written statement also. So one of the fair in civil division petition, it become infructuous. That I have stated in my affidavit in opposition, which they have not denied. So therefore, my lord, this civil division petition, kindly my paragraph number 2 in affidavit in opposition may be taken note of, is not maintainable to my humble understanding to law. So this is on item 13. And item 14, my lord, both may be decided and disposed of together. In item 14, I'll be submitting some citations, my lord.
In item 14, you are the petitioner and is the
Respondent, my lord. Same party, my lord. In this case, my lord, what happened? My first leg of submission. When the complaint case comes, the learned magistrate has to see. Firstly, he ought not to have taken cognizance and thereafter directed for registration of FIR. To that effect, I am submitting authority, my lord. Thereafter, my lord, even after examining the complainant and other 3 witnesses, what is the case is that, my lord, even perusing those evidences, my lord, it does not disclose any offense for giving such direction for a registration of case. Therefore, I have prayed for setting aside of the entire CRKS proceeding, as well as the order impugned dated 3/12/2018, whereby the learned CJM has directed to register the case, that I have put it to challenge.
3/12/1918.
3/12/2018. 2018. So factual aspect, my lord, on foreground, firstly, that even if the entire deposition is taken into consideration, there are no any offenses that is made out, and the learned CJM 0 ought not to have taken cognizance, is because for the offenses that he has taken cognizance is absolutely barred under section 195 CRPC. That is stated in my petition, well, that may be kindly taken note of. And thereafter, my lord, after taking cognizance, learned trial court below ought not to have directed for registration of the case. So these 3 are the basic grounds. In the case of Suresh Chand Jain, my lord, reported in 2001 to SCC 628, paragraph 7, 8, 9, and 10.
Seven, 8, 9, and 10.
7, 8, 9, and 10. 7 to 10. May I read? 7. In our opinion, the aforesaid direction given by the learned single judge of the Punjab and Haryana High Court in Suresh Kumar versus so-and-so case is contrary to law and cannot be approved. Chapter 12 of the code contains provisions relating to information to the police and the powers to investigate. Whereas chapter 15, which contains section 202, deals with provisions relating to the steps which a magistrate has to adopt while and after taking cognizance. This may be kindly taken note of. 202, that is after taking of cognizance. of any offences on a complaint. Provision of the above two chapters deal with two different facets altogether, though there could be a common factor, that is complaint filed by a person. Section 156 falling within chapter 12 deals with powers of the police officers to investigate cognizable offence. True, section 202, which falls under chapter 15, also refers to the power of magistrate to direct an investigation by a police officer. But the investigation envisaged in section 202, that is after taking cognizance, is different from the investigation contemplated in section 156 of the code. Section 156 of the code reads thus: so and so, so and so, so and so, my lord. Paragraph 8. The investigation referred to therein is the same investigation. The various steps to be adopted for it have been elaborated in chapter 12 of the code. Such investigation would start with making the entry in a book to be kept by the officer in charge of a police station of the substance of the information relating to the commission of a cognizable offense. The investigation started thereafter can end up only with the report filed by the police as indicated in section 173 of the code. The investigation contemplated in this chapter can be commenced by the police even without the order of a magistrate, but that does not mean that when a magistrate order an investigation under section 156(3), it would be a different kind of investigation. Such investigation must also end up only with the report contemplated in section 173 of the code. But the significant point to be noticed is when a magistrate order investigation under chapter 12, he does so before he takes cognizance of the offense. That may be kindly taken note of. In my case, he took the cognizance, recorded the statement on oath that is not permissible. Thereafter, he cannot direct for registration of case. Now, paragraph 9. But a magistrate need not order any such investigation if he proposes to take cognizance of the offense. This is also important. Once he takes cognizance of the offense, he has to follow the procedure envisaged in chapter 15 of the code. A reading of section 2021 of the code would convince that the investigation referred to therein is of a limited nature. The magistrate can direct such an investigation to be made either by a police officer or by any other person. Such investigation is only for helping the magistrate to decide whether or not there is sufficient ground for him to proceed further. So this is after taking cognizance. This can be discerned from the culminating words in section 202, subsection 1, that is, court or direct an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. This is because he has already taken cognizance of the offense disclosed in the complaint, and the domain of the case would thereafter vest with him. So, my lord, what this authority says, my lord, that once you have taken the cognizance, so the entire matter is within your session, and you cannot direct for registration of FIR. But for limited purpose, of course, like if suppose some document is disputed, to sending that document to FSL, for those purposes, for example, he can direct the police, but he cannot direct for registration of FIR after taking of cognizance. That is one aspect. And another, section 195 CRPC, that clearly bars the offenses under which he took the cognizance. This is Narendra Kumar Srivastava, 2019 3 SCC 318, paragraph 15, 16, 17, 20, and 24. This is on the embargo that is put here under section 195 CRPC.
Yes.
Paragraph 15, paragraphs, my lord, 15, 16, 17, 20, and 24. Paragraph 15, married. Section 195 CRPC lays down a rule to be followed by the court, which is to take cognizance of an offense specified therein, but contains no direction for the guidance of the court, which decides to initiate prosecution in respect of an offense alleged to have been committed in or in relation to a proceeding in the latter court. For that purpose, one must turn to section 340, which requires the court desiring to put the law in motion to prepare a complaint, either suo motu or an application made to it in that behalf. 16, paragraph 16, section 340 CRPC reads as follows: so and so, so and so, so and so. Paragraph 17. Section 340 CRPC makes it clear that a prosecution under this section can be initiated only by the sanction of the court under whose proceedings an offense referred to in section 195(1)(b) has allegedly been committed. The object of this section is to ascertain whether any offense affecting administration of justice had been committed in relation to any document produced or given in evidence in court during the time when the documents or evidence were in custodial legis, and whether it is also expedient in the interest of justice to take such action. The court shall not only consider prima facie case, but also see whether it is in or against public interest to allow a criminal proceeding to be instituted. Paragraph 18. This court in Chajuram versus Radeshyam held that the prosecution under section 195 CRPC could be initiated only by the sanction of the court and only if the same appears to be deliberated and conscious. It emphatically held as under 7, the prosecution for perjury should be sanctioned by courts only in those cases where the perjury appears to be deliberate and conscious and the conviction is reasonably probable or likely. No doubt, giving of false evidence and filing false affidavit is an evil which must be effectively curbed with a strong hand. But to start prosecution for a perjury to readily and too frequently without due care and cautions and on inconclusive and doubtful material defeats its very purpose. Prosecution should be ordered when it is considered expedient in the interest of justice to punish the delinquent, and not merely because there is some inaccuracy in the statement which may be innocent or immaterial. There must be prima facie case of deliberate falsehood on matter of substance, and the court should be satisfied that there is a reasonable foundation for the charges. In Santosh Singh versus so and so, this court has held that every incorrect or false statement does not make it incumbent on the court to order prosecution. Kindly come to my lord. Paragraph 20, my lord. This court in MS so and so has clearly held that private complaints are absolutely barred in relation to an offense said to have been committed under section 193 IPC, and that the procedure prescribed under section 195 CRPC are mandatory. It was held in that paragraph 5. Chapter 11 IPC deals with the false evidence and offenses against public justice, and section 193 occurring therein provides for punishment for giving or fabricating false evidence in a judicial proceeding. Section 195 of the CRPC provides that where an act amounts to an offense of contempt of the lawful authority of public servant or to an offense against public justice, such as giving false evidence under section 193 IPC, etc., or to an offense relating to documents actually used in a court, private prosecutions are barred absolutely, and only the court in relation to which the offense was committed may initiate proceedings. Provision of section 195 CRPC are mandatory, and no court has jurisdiction to take cognizance of any of the offenses mentioned therein, unless there is a complaint in writing as required under that section. It is settled law that every incorrect or false statement does not make it incumbent upon the court to order prosecution, but to exercise judicial discretion to order prosecution only in the larger interest of administration of justice. So this paragraphs, my lord, the ratio is that the offenses that are described under section 195 CRPC are absolutely barred on the private complaint. Until and unless there is a complaint by the court or by its subordinate authority, no court can take the cognizance. Here in this case, if your lordship kindly peruse the on factual aspect, page 82 of my petition. This is the impugned order of the learned CGM 0,
Page 82.
page number 82. The direction to register a case by the learned CGM was under section 181/204/209/465 34 IPC. And now page 82. Out of these 5 sections, my lord, sections 181 and section 209 comes within the purview of section 195 CRPC. That embargo is there for taking cognizance of offenses under section 181 and 209 IPC. But the other side may say, since there are other independent offenses that falls under section 204/465, is because those sections do not come within the purview of section 195. Therefore, I am placing one judgment wherein the Allahabad High Court has held that even the offenses, my lord, are of different kind. Some may be barred under section 195 CRPC and some may not be barred. In such a situation, if those offenses, my lord, even those some independent offenses comes within along with those sections that is envisaged in section 195 CRPC, if those are out of same transaction, then court should not take cognizance of those offenses also. Paragraph 21, man.
Yes.
May I read paragraph 21? In view of the above citation, I am of the view that even if other section, that is 419, 420, 408, and 471 IPC, are found to be made out despite their being not mentioned in section 195 CRPC, it cannot be held that the proceedings in the present case would not stand barred under section 195 CRPC, as the offenses under the said sections appears to be connected and to have been committed in course of the same offense that is under section 177 and 188 IPC. Therefore, I am of the view that the proceedings in the present case appears to be barred by provision of section 195 CRPC and are liable to be set aside and quashed. So this proposition, my lord, because tomorrow the other side may say, so therefore I am placing this citation, because there may be some other offenses for which learned magistrate has taken cognizance, like in our case 465. But then when some sections are there that are barred under section 195 CRPC, and those offenses are out of same transaction, then under section 195, the entire section, those independent sections also would be barred. And this is also in same line, my lord. Suresh Chandra Srivastava, reported in 1984, 3 SCC, page 92, paragraph 6. In these circumstances, therefore, it is not necessary for us to go into the broader question as to whether if offenses under section 467, 471, and 120 IPC are committed, the complaint could proceed or not. The law is now well settled that where an accused commits some offenses which are separate and distinct from those contained in section 195, Section 195 will affect only the offences mentioned herein unless such offences form an integral part so as to amount to offences committed as a part of the same transaction. My lord, in which case the other offences also would fall within the ambit of section 195 of the code. This is a Honorable Apex Code, my lord, and is of
Followed by
Cool.
the Allahabad High Court.
one is Allahabad High Court and this is of Apex Court. And this is a full court, my lord. 3 benches. So under these facts and circumstances of the case, my lord, the learned Chief Judicial Magistrate has erroneously taken the cognizance and directed to register the case and the offences that are barred under section 195. And also, after taking cognizance, ought not to have directed to register FIR. And even after perusing the entire evidences, deposition, also it does not disclose any offense so as to direct the registration of FIR. On these 3 grounds, I humbly pray this honorable court to set aside the entire proceeding in CR case number 32 of 2018 pending before the learned Chief Judicial Magistrate, as well as the Nyapin PS case number 4 of 2019 registered under section 181-204, 209, 465, 34 of IPC. That's all.
Yes, madam.
Oh, he is the petitioner, so you are the.
Respond.
Vice versa now. Vice versa, same part.
My colleague, madam. My lord, the learned court below has passed rightly. There is no any wrong passed by the learned court below. Because my learned senior counsel is talking about CRPC 195. My lord, CRPC 195 talks about when offense is committed in the court proceeding. So in that case, the court cannot give direction or take cognizance. Because when an offense is committed in the court proceeding, court has to file complaint. But in this case, this is not the case. My lord, against this, I file complaint, share case before the learned CGM, learned court below. Because earlier, I filed FIR before me open PS. This PS case was, this offense raised in the FIR was not committed in the court. It was committed outside of the court. So this FIR was not registered. Then I filed share case before the learned CGM court below. My lord, please again peruse page number annexure P, page number 16 is FIR filed by me before the open PS. This FIR is alleging of forging document, making false decision order of land dispute case. Because there was, my lord, basically there was a land dispute between two villages in Kurungkume district. The land dispute is still not settled, is still not decided by any authority. But
CR
this,
case number 32 by 2018.
my lord,
You are asking me to produce CR annexure 1. CR case number 32 of
my
2018.
lord, annexure P, page number 16 is my FIR filed before open PS.
Page number 16 or 16.
16. Annexure P, my lord. It is written as 16 or 14. Annexure P, my lord.
Annexure P.
P, yes, my lord. 74, I think, 74, my lord, page number 74. Yes, annexure P. My lord, this in this FIR, because there is a land dispute between the two villages. Land dispute is still not decided by any court. But what happened? The Gangburas and other Gangburas, head Gangburas, they prepare false decision order. And by forging signature of some other person. So FIR allegation against the FIR that is 25/6/2017. There is serious allegation of forging document. So my lord, the case is still not settled, but they have decided prepared full decision order. And this FIR was not registered. When this FIR was not registered by Open PS, then I filed complaint in the form of share case before the learned CGM court below. And after filing complaint before the learned court below, the complaint was, witness was taken a statement recorded. My lord, then after taking recording of the statement, the learned court accordingly directed the police to case register because there is a serious case, forging of document. So my learned senior counsel, what about he is talking about that 195 is not reflected in this case. And some document and that false decision order was used in the same learned court below. Then I also raised the learned court below to make a complaint because offense was committed in the court, in and outside the court. So learned passing of this learned court below is nothing wrong. This is absolutely correct. As there is serious case against this respondent. That's all, man.
You'll reply?
Just rejoinders. My brother is supporting my case. Yes, because only had it been that is the case, then to definitely learned CGM has erroneously taken cognizance of those offenses that even they have not alleged as per their submission. And that is absolutely barred under section 195 CRPC. Kindly that may be taken note of. And kindly come to page 16 of my petition. Because there is some contradiction in the submission and in the return by my learned brother.
Page 16.
Page 16. This is their complaint petition, my lord. In the course title, may I read, in the matter of a complaint under section 190, read with section 340 of the CRPC, praying for taking cognizance or making complaint against the accused person who have committed the offenses under section 176, 181, 193, 196, 204, 209, 420, 465, 34 IPC. So this is their prayer only. They kindly take cognizance under such and such sections. So accordingly, impugned order out of this mentioned section 181, 204, 209, 465, 34 IPC was taken cognizance on these offenses. However, out of these sections 181 and 209 are absolutely barred under section 195. That is my reason. Kindly that may be taken note of. Highly obliged.
Reserve it for judgment. To item 14. Item 14 to item 13. Matter who? Because item 13, edit item 14. In my division, I think the puzzle is also with me. Thirteen and 14, no?
Supplementary hearing.
Supplementary hearing.